Ladies and gentlemen, from the Charles Koch Institute, Vice President of External Relations, Katie Roberts.
Good morning, everyone. Thank you for joining us here in New Orleans. We're hopeful that together we can identify and propose some of the necessary reforms in our criminal justice and policing systems. To begin our program this morning, we'd like to highlight a legal advocacy nonprofit firm, Cause of Action, that has done some amazing work in this space with a recent case that went all the way to the Supreme Court. Unfortunately, the executive director, Dan Epstein, can't be with us today due to a family emergency, but in his absence, we hope you'll enjoy this video. After the video, Vikrant Reddy will come on stage and offer some remarks about the case and about the organization.
I am John Yates. I live here in Bradenton, Florida, next to Cortez, Florida, where I used to fish out of. I've been fishing my whole life. I grew up in Ohio. We always had a bait store, been fishing with my dad since I've been probably about 2 or 3. We fished the Great Lakes.
We ended up here on the island just for one night. That was 18 years ago. And we're thinking, why do we want to leave? Everybody wants to be here. So we stayed.
And so I jumped on a grouper boat at the deckhand, and a short while later, a guy threw me the keys and I started running the boat.
In 2007, Mr. Yates was out on a routine excavation searching for red grouper. Around that time, there was a federally deputized Florida Fish and Wildlife officer that had noticed the boat. They stopped the boat, boarded it to conduct a routine inspection. Of the fish, there were 72 that the officer noted that were below the federal size limit.
What he told Mr. Yates was, you need to go back to the dock when you're finished today, and we're going to remeasure these grouper. And so Mr. Yates complied, went back to the dock, and when the grouper remeasured, they were a few centimeters different than the original size.
Rather than 72 of the fish being measured as undersized in that catch that was set aside, there's only 69 now that are being measured undersized.
And so what this state officer did was essentially cite him for a violation.
Basically, we're missing 3 fish. But yeah, the ticket was it. We thought once you get your ticket, you right to pay your fine. We thought it was over.
This all of a sudden became a federal crime. The Middle District of Florida prosecuted him under a statute that was designed for the business world, Sarbanes-Oxley, which is the law that was passed after the Enron scandal to go after those individuals who are under a federal investigation who might be shredding records and deleting computer files. A commercial fisherman was held to have essentially obstructed a federal investigation through the destruction of a tangible object now defined as a fish.
You took a fisherman at work, his fish thawed out. You charged him with 3 felonies that carried 30 years. Because 72 fish offshore, 69 fish is what they found on shore.
So at that time, they handcuffed me, took me to the Coast Guard station, informed me that I was going to jail over the NOAA incident from 2007. So we drove me, put me in jail, and that was it.
We saw this case as a stock example of overcriminalization. We realized that this was an opportunity to work with Mr. Yates, to work with his lawyers at the Federal Defender's Office, and stop talking about overcriminalization as an academic concept that happens already when people go to jail, but actually do something now to make sure that he never had to have his livelihood threatened by getting this case reversed at the starting point. Our petition for Supreme Court review was an example of combining our legal analysis with our investigative work that really showed that this overcriminalization problem at its core stems from corruption, from abuse inside of federal agencies that directly affected this individual's livelihood.
Going to the Supreme Court was something I'll probably never forget. It was eye-opening, and it was validation, I think, more than anything. Yes, this is what we've been saying since day one.
That was a split decision. It was a hair away from essentially threatening not just John Yates, but any individual who gets into the crosshairs of the government.
Once cause of action got involved and all the amicus teams, it was, somebody cared. Somebody gave a shoot. I mean, I'm just so blessed that they did get involved. Nothing else has changed around here. I still work 2 jobs. He still has known as the fish shredder, the fish thrower. He never threw any fish.
He had blackballed me from fishing for the last 6 years. I tried to open up some little furniture store, which I invested a little bit of money in, but I ain't made no money there to make a living on it. All I'm doing is breaking even and working for free, basically. You know, I'm probably well over $1 million in lost income in the last 6 years. Since then, I haven't even tried to go back to fishing.
They really just wanted to live their lives, and the government came knocking, and they did what they thought was appropriate. John Yates did what he thought was right, and ultimately, because the government went after them, his livelihood was threatened. And this is an individual and a family that cares deeply about this country, that are deeply patriotic. Good, innocent Americans are the ones who get targeted.
If it helps the betterment of all and we had to take a little butt kicking for a little while, okay. And you take it and you move on. But if you have the ability to stand up and fight for something that needs to be fought for, you better do it.
Good morning. Thank you all for being here this morning. That was really a fantastic video and a fascinating case to be a part of. The opinion that the U.S. Supreme Court finally produced was the first time in the history of the Supreme Court that the word overcriminalization was actually used in the body of a U.S. Supreme Court opinion. It had been used in footnotes before, but nobody reads the footnotes. So it was really an incredible case to be a part of. And when I was at the Texas Public Policy Foundation, my previous position before I joined the Charles Koch Institute, we actually had the great honor of getting to join cause of action in submitting an amicus brief to the Supreme Court in that case. And it was really one of the great thrills of my life. It's a real thrill to be able to file a brief, of course, in front of the Supreme Court. But I will let you in on a little secret. There's something like 2,000 or 3,000 federal judges across the United States, and the 9 judges on the Supreme Court, although they get all the headlines, they do the least work. Don't tell Justice Scalia I said that, by the way. But if you talk to the judges at the district court level and the ones at the federal appellate court level, they are working constantly. They have to take every single case. They don't have what we call discretionary review. It comes before them. They've got to decide it. And they know a lot about law in the United States and a lot about criminal law in the United States. We have got 2 judges this morning, one from the district court and one from the federal appellate bench, who have combined, I think, something like 6 decades of observing the criminal justice system in the United States. They've got a lot to say about it. They've got quite a few opinions. It's a real delight to have them here, and we are going to have, I think, a fascinating conversation with the 2 of them this morning. So let's start by welcoming Judge Ricardo Hinojosa, who was appointed to the U.S. District Court for the Southern District of Texas in 1983. He keeps chambers in a small town in South Texas called McAllen, which is one of my favorite little towns in the world, I will say. He served on the U.S. Sentencing Commission since 2003 up until just this year, serving as chair of the commission from 2004 to 2008, acting chair in 2009, and then vice chair in 2013 and 2014. In 2011, Judge Hinojosa was presented with the Edward J. Devitt Distinguished Service to Justice Award. He has a bachelor's degree in government from the University of Texas at Austin and a law degree from Harvard. Ladies and gentlemen, Judge Ricardo Hinojosa. Thank you. Our next speaker this morning is Judge Richard Nygaard, who in 1981 was appointed to the Erie County Court of Common Pleas, which is the Pennsylvania Court of General Jurisdiction. Then in 1988, he was appointed to the U.S. Court of Appeals for the Third Circuit by President Ronald Reagan. In 2005, he took senior status. He maintains chambers now in Erie and in Philadelphia. Judge Nygaard received his Bachelor of Science degree from the University of Southern California and his JD from the University of Michigan. He also has a Doctor of Laws from Edinburgh University in Pennsylvania. Ladies and gentlemen, Judge Richard Nygaard. Judge, thank you so much. Good morning. Well, I think we should start by just looking at the news. And I'm going to direct the first question to you, Judge Hinojosa, because you have extensive experience with the Sentencing Commission. If anybody read the news over the past month, they would have seen this shocking headline that 6,000 offenders are about to be released back into society, and that this was happening as a result of a decision made by the U.S. Sentencing Commission. Of course, you were there at the time, and I'm wondering if you could explain, maybe in a little bit more detail than some of those newspaper articles did, what exactly the decision was and what evidence you all reviewed to come to such a decision.
Well, first of all, I have to say these chairs are much more comfortable than the ones I have at the bench. And so this might make this a little bit harder from that standpoint. But this really goes back to 2007. When the commission in the 90s had tried to lower crack cocaine penalties and change the ratio and send it to Congress. Everything that the Sentencing Commission does has to be sent to Congress, and they have 6 months within which to reject it. And that was one of the two things that was rejected that the Sentencing Commission has done, and that was in the 90s. And so for a long time, the commission tried to convince the public and Congress that the crack cocaine ratio was too high and that to the powder and that something needed to be done. Yet there was no action, and finally the commission, when I was chair, we decided that we would lower penalties for crack still within the mandatory minimums and lower it 2 levels, and that we would proceed in that fashion to try to do something to try to even it out just a little bit within the statutory minimums. We did that in 2007. It was not rejected by Congress. We voted to make it retroactive. It isn't that the commission just decides we're going to do retroactivity. By statute, the commission is required every time that it lowers penalties with regards to a guideline to make a determination as to whether it should be retroactive to apply to those that are in the federal prison system. And so we made it retroactive. One of the things that we decided to do was that we would conduct a recidivism study for a 5-year period to determine, is there an issue with regards to letting people out somewhat earlier than they were supposed to be out from the standpoint of recidivism. When the study was done, it showed that the recidivism rates were basically the same whether they had served their entire sentence or whether there had been a reduction. And there were 2 groups that were studied, one that was affected by the reduction and another group that was not. You do it by criminal history and everything else being the same. It is a high recidivism rate. It is 47% for the group that did not get the reduction, 43% for the group that did get the reduction, but nevertheless, it did show that there was not a higher recidivism rate. In fact, it was pretty even. And so then the commission decided, there had been criticism for a long period of time that the guidelines were tethered, of course, to the mandatory minimums, which I think they should have been, but that the ranges were higher than the mandatory minimums to give some credit for acceptance of responsibility. The commission, having reviewed the study, decided we should do the same for all drugs and still be within the mandatory minimums based on congressional intent of mandatory minimums. And it won't make much of a difference with regards to recidivism in all likelihood, and we should proceed to do that. And then, having done that, like it always does when there is a reduction, the commission had public hearings. It was known to everybody that the commission was considering this. There is input from judges, there's input from Congress, there's input from the public, there's input a lot from defendants and their families, I have to say. You receive those letters by the thousands. And groups that are interested, such as this group. We have public hearings, the commission has public hearings, and after having done that, the commission decided to go ahead and make this retroactive. It was sent to Congress, it was there for the 6 months, there was no congressional action to the contrary. There was a lot of publicity at the time, and now it's more recent because what the commission did was it made it effective November 1st to give the courts the opportunity to make the decision as to these individual cases and to give them attention and also give the individuals the opportunity to go through the halfway house or residential treatment before they get just strictly on supervised release. There is a slight difference with regards to drugs in that a good percentage of the drug defendants in the federal court system are non-citizens of the United States. The makeup of the federal system is very different than some of the state systems. The federal system, number of cases in felony and Class A misdemeanors, 52% are Hispanic, 23% more or less are white, and about 20% are black or African American. And so therefore it is a very different makeup than the state systems. Part of it is affected by the southwest border and drug trafficking and immigration cases. And so some of these individuals will be sent back to their countries. They get turned over to immigration, and that is a percentage of some of the drug trafficking cases that will have received lower penalties. And so that's the process. It's not a secret process. It's not one that is done lightly. It is not one where the commission doesn't consider the issues involving the defendants and their families, but certainly public safety. And the commission then directs judges to do the same. Judges don't have to grant these motions, and the statute itself says that the motions can be brought by the defendants, by the Bureau of Prisons, the head of the Bureau of Prisons, or by the court on its own motion. It does present more work for some courts because some courts have higher number of drug trafficking cases than others. That was taken into account also, and that was part of the reason for the November 1st date as opposed to
Your court is a court like that, in fact, right?
Yes, it is, and so a lot of the southwest border courts. But crack was the same way. There were some courts, not necessarily on the border, but in other places where they had a good number of cases that had to be handled in certain areas. They were handled well and timely, and it worked well. And so having had that experience, that's what led the commission to proceed in this fashion with regards to drugs in general.
Could you, I think maybe I should have asked to first of all, talk a little bit about what the Sentencing Commission is and its background and how it started. I think maybe that would be very important and instructive for everyone.
Well, I guess I'm a little different than most judges. I've been on the bench 32 years. And so I have seen us go through a lot of different periods of how we view sentencing and what kind of systems that we have. My first 5 years were complete discretion on my part. And I have to share something with you. When I became a judge, I had done mostly civil work, and I had been out of law school about 8 years. I had clerked 1 year for a state Supreme Court justice. And I have to tell you that I thought sentencing was going to be a pretty easy thing to do. Somebody's committed a crime, public's been hurt, how hard can that be? Well, it wasn't hard till I had to do the first one. Then I realized this is not as easy as one could possibly think that it is. It's the defendant, yes, and it's the family, and also at the same time it's the public, and federal court's different. We don't have that many cases where we have actual victims, because most of the time it's a drug case or an immigration case or a firearm case where we don't really have the actual victims in front of us, or fraud. A lot of times the fraud is against the government. And so it isn't like a lot of the state cases where you actually have the victims come address you, but at the same time, it's the unspoken, the public damage that has been caused. And so trying to put all that together is not as simple as it might seem. I think sometimes we, as the public, can sometimes have certain views of, well, somebody did something wrong, they need to pay this, they need to do that. But it's a very complicated process, and I think that was touched on yesterday by some of the people who spoke at the introduction. And for 5 years, really, when somebody came in front of me and the maximum was 20 years, I could have picked probation or 20 years. I wasn't going to get reversed. There was no way that was going to happen. It was just up to me. Most defendants in federal court plead guilty, It's about 97, 98%. It was that way before the Sentencing Commission and the sentencing guidelines. But as you can imagine, we all come from different backgrounds and we have different viewpoints about certain crimes and certain ways that they are committed and what we think. And we have regional differences. We are a huge country. Texas is an example. And I always say Texas is bigger than France, which it is. And so we are a big country with a lot of different viewpoints. And sentences were varying quite a bit all over the country. The Vietnam War was going on during a certain period of time where people were burning their draft cards. In San Francisco, people were getting arrested for this. There was a number of the judges who all gave probation, one who always gave the maximum. That was an example of the disparity that was occurring. Sometimes within courthouses, some of us had different viewpoints about drug trafficking and certain crimes than other judges. I'm not saying any of us were right or any of us were wrong. We had different viewpoints. And so in a bipartisan fashion that took about 10 years, the Sentencing Reform Act of 1984 was passed. Senator Kennedy and Senator Hatch were both co-sponsors and very firm behind this theory of trying to have people punished who commit the same type of crime in the same fashion with the same kind of background in the same way all over the United States. And so the Sentencing Commission was created to promote and promulgate guidelines. It also has to be made clear that from the very start it was understood that there would be departures in cases, that it was never meant to be that automatically you would pick the guideline range, that there would be cases. In fact, some of the congressional history indicates that the percentage was supposed to be as high as possibly 20% of the cases where judges, for some particular reasons, would find grounds that the guidelines didn't fit in a particular case. They went into effect. A 7-member commission was created with 2 ex officios. The 7 members served for 6-year terms. You cannot serve more than 2 terms. It is a bipartisan commission. You cannot have more than 4 members of the same party on the commission at the same time. It is weird because those of us who are federal judges don't get really labeled by party once we become federal judges. But on the Sentencing Commission, where the requirement is that there be at least 3 judges on the commission, we do get labeled by a party, and it's usually based on who appointed us. The commission operates on a yearly basis, has a staff of about 100 people that does a lot of research work, a lot of data collection. Every single document that is used with regards to sentencing, out of 5 documents that are used, it gets sent to the commission for every single Class A misdemeanor and federal felony conviction. The commission has an excellent database with great researchers that work on it and present that to the commissioners on a regular basis to determine whether the guidelines should be changed or not. The initial commission worked with thousands of pre-sentence reports and the actual amount of time that people were spending in prison. One of the problems for our sentencing judges pre-guidelines was there was parole. And as a judge, I had no idea how much time the person was actually going to spend. I had an idea of what I thought was the appropriate amount of time, but all I knew was that this person is going to probably serve at least 1/3 of the time and probably not more than 2/3 of the time. So there was not that openness with regards to the sentence, in the sense that a judge was guessing how much time it would take to say for the actual time that the person was going to serve. Parole was done away with by the Sentencing Reform Act, but there is a 15% credit with regards to good time if you have a sentence of more than 12 months. That is important from the standpoint of the federal prison system. It's something that is used with regards to making sure that there is no problem with regards to behavior within the prison system to have the good time credit. And so the commission has been in existence since then. One of the things the commission in the statute is which authorizes is told is if you do reduce the sentences, you will have to determine whether they should be applicable to anybody who's already serving a sentence on a higher guideline. All of this is taken very seriously by the commission and involves input and public hearings and a lot of data information. It is not something that the commission jumps into lightly. It is not something that is done on a whim. It is something that is clearly thought out from the standpoint of the defendants as well as the public. And so nothing that the commission has done with regards to retroactivity or any reduction in sentence, or sometimes just a brand new guideline, is done without much thought, without having had a lot of thought. And so I think it's important for us to realize how the commission operates. It's something I have to tell you, when I was a sentencing judge, without being on the commission, sometimes I'd look at that manual and go, who came up with this? How did this happen? I developed a lot more respect of who came up with this and how did this happen once I actually served on the commission, based on the input that comes from a lot of people rather than just me.
You know, what's interesting is you're talking about this period for about 30 years or so, and Judge Nygaard, you've observed all of this also, where one of the biggest criticisms of the American judiciary was that it was too all over the board. The sentences were so different depending on who the judge was, and we needed some way to standardize them. And one way of doing that, as you point out, was the commission and the sentencing guidelines. But I think another thing that was attempted was the introduction of more mandatory minimum sentences, especially at the federal level. And I would think if I were a judge that I would kind of bristle at that. I would say, well, gosh, I don't want some guy in Congress who doesn't actually know this case or know this defendant telling me what I have to sentence this person to. I'm the one who's got the case file in front of me. You think, is that how judges feel about mandatory minimums? Is Congress?
That's how I feel.
That's how you feel.
Yes, yes, I do. I don't bristle, but I do believe that the mandatory minimums set someplace in the halls of Congress are not dealing with the realities of the street. And I was a state trial judge back pre-state guidelines, and was able to deal with the issues of the person, not necessarily the crime. And I found that to be more productive or easier than when I had to sentence somebody to a minimum, when I had to obey a mandatory minimum, when I firmly believed that this person had some redemptive value. And shortly after the guidelines in the state kicked in, our Intermediate Court of Appeals began to issue opinions making them presumptive sentences. Then the next thing came along were mandatory minimums. And I recall one time I had a young man. He he pled guilty to driving under the influence, in which a death occurred. So it was homicide by motor vehicle while under the influence. Mandatory minimum 5 years. He was a young man, blonde, curly haired, plump, boyish. The victim's mother came into court, testified on his behalf, and but yet I was compelled to sentence him for 5 years. And I don't know what happened to him, but I do know what happens in prison to people who look like that, innocent. And I'm sure that he became prey to the predators very quickly. So I have a rough time with that. And as you know from having read some of my essays and law review articles, that my theme in sentencing, my theme in corrections, if you will, has to do with correcting, not simply a period of time. And I've likened it to, in medicine, if you were treating all illnesses with the same pill, except that you just prescribe more pills if the person was more seriously ill. And it's about the same. So time doesn't do it. But not all of that is in the sentencing, though. A lot of that is in prison. And I've campaigned vigorously for the last 30 years for prison reform as well, and reentry programs.
Judge Hinojosa, do you feel similarly about mandatory minimums?
I don't want to hear a gasp here, but I don't have a lot of trouble with the issue of mandatory minimums, as long as they do have, in which Congress corrected, the safety valve provisions, where you have no prior criminal history, you're not an organizer, manager, or leader, or supervisor, you're not, there's been no violence involved. And in fact, the commission itself, while I was on it, has recommended that Congress consider an expansion of the safety valve. That made it much easier to deal with. Drug trafficking is a hard one, because I know sometimes we label it as nonviolent drug offenders. In the federal system, it's extremely rare for somebody to be in prison simply because they're a drug user. They may be drug users, but if they're a drug trafficker, they're involved with serious amounts of whatever type of drug is involved. And for those of us on the southwest border, and the violence that has been created in countries like Mexico because of the drug usage on this side of the border and the drug trafficking on both sides of the border. I grew up on the border, born and raised there. Not unusual if you came to visit us that we would have dinner or lunch or whatever in Mexico. It's just right across, I mean, no problem whatsoever. Some of us have not crossed in 7 or 8 years, and we certainly would not take you for lunch or dinner. Some of it has spilled over to some extent with regards to home invasions and fights among themselves. And so it is a very complicated matter. And so do I automatically say mandatory minimums are bad? I think mandatory minimums in some cases with regards to the right safety valve provisions aren't necessarily a terrible thing. There is a lot of communication among people who violate the law with regards to sentencing and what they might be. There were times when you would see 99 kilograms instead of 100 kilograms because they knew when the mandatory minimums were going to come in. And so there is a lot of communication that goes on and a lot of knowledge with regards to, at least at the federal level, with regards to what penalties might be. And so that has an effect. And so, like the commission, I share the view that we had a divided commission on being opposed to mandatory minimums, so we didn't express a viewpoint as to whether they were good or bad, but we did express the viewpoint unanimously that the length of the mandatory minimums should be seriously looked at and reduced, and certainly the safety valve should be considered for expansion.
I want to shift gears just a little bit and talk about that video that we played before we came out here on the Yates case. Well, I don't want to talk about the video specifically, but I want to talk about this term overcriminalization. You hear it a lot. A lot of federal judges, a lot of people in the advocacy community feel like we have an overcriminalization problem. We have too many criminal laws. We have an over-federalization problem, too many federal criminal laws. In fact, I recall Justice Scalia was testifying in front of Congress, and he said, one of the biggest mistakes we ever made was taking a lot of very routine drug offenses and putting them into the federal courts when they really ought to be in the state courts. But these over-crim and over-federalization problems, are these real?
Yes.
Yes? This is not a fabrication of the advocacy community?
No.
Judge Hinojosa, you feel the same way?
I'm not so sure that in the federal system we have overcriminalization. We have had an increase in the number of people in the federal prison, but we have had an increase in the number of cases brought. The interesting thing is since 2011 to now, there's been a 12% drop on the number of cases that have been brought in the federal system. And so maybe that's prosecutorial discretion with regards to what cases should be or not brought. I'm also a product of being on the southwest border. There are many cases in the southwest border that get sent to the state that don't get brought to the federal system because they're not big enough for the federal system. You would be surprised at what it takes to come into the federal system on some of the drug trafficking cases. The ones at the bridge, yes, and the crossings, they usually get brought, but there are other cases that do not get brought because they don't reach the threshold as to the amounts. And that's with regards to harboring and transporting aliens also. It's not unusual for somebody to come to me when they've been transporting 10 or 11 people who are in the United States illegally, but they've been stopped 3 or 4 other times, but since the number was less than 6, they didn't prosecute them. And so I think it depends on where you are as to how you view this. The lengths, like I said before, are certainly something that we need to look at, is how much time does it actually take, and how much good are we doing with regards to people in prison. I think I certainly agree with the judge. I don't know that we're doing the best we can within the federal prison system as to how we make somebody better. From the standpoint of people who are non-citizens, they will be deported, and I don't know how much training, how much counseling there was with regards to how you can find a job in a country that some of you have not lived in there very long, but you've lived mostly on this side of the border. And so I think more attention to that kind of situation would be helpful. And I have to say that it was also mentioned yesterday, and I think being smart on crime means preventing crime. The common denominator in my 32 years on the bench of sentencing so many people and having to deal with those issues, and it is complicated and difficult, the common denominator is dropout. In the federal prison system, 46% of the individuals there have not finished high school. Only about 6% have finished college. Employment, no encouragement from friends and family. And until we fix those factors before somebody hits the prison system, I wish the groups such as this that are so interested in this would also pay attention to those factors before somebody comes into the criminal justice system. Because we cannot solve this problem, and certainly we cannot solve the problem of the racial disparity within the system unless we address those factors before somebody's already in the system. It's much harder for us to make things better for someone once they're in the system, mainly because of the way we operate our prisons, and we certainly should try to do our best there. But after thousands of pre-sentence reports that you read, when you pick it up and you read the background, then you realize there isn't some kind of mystery as to why we're here with this particular person. It was meant to be, unfortunately. And you try so hard when you sentence somebody, and I have to say that I can count on this hand the number of people that I found nothing good to tell them about themselves, because there is goodness in just about everybody. But at the same time, we don't all come from the same kind of equal situation as far as what we've been lucky enough to have. And so I think that in order for us to solve our overcriminalization and over incarceration rates, we need to address it even before then.
You know, you answered a question that I wanted to ask in a roundabout way, but I wanted to ask both of you, and I'm going to ask you now, Judge Nygaard.
This is harder being a witness than it is when I'm the judge.
What I wanted to ask is, you have all these people in the room who are from the advocacy community. I'm from the advocacy community, and I wonder how you would complete the sentence. Look, I'm a criminal justice reformer too, but what you guys just don't get is blank. And I think you've answered it by saying, well, the public safety component isn't talked about enough. What do you think, Judge Nygaard? What are we all missing in the room that we should think about more?
Yeah, I don't know that you're missing anything. I would guess that we're probably pretty much all on the same page looking for some reform in the system up and down. Most of my experience, interestingly enough, although I've been a federal judge for 27 years, is within the state sentencing and within the state penal system. I visit prisons all across the tri-state area, Ohio, Pennsylvania, New York. I have a program whereby I accept donations of books and I take them out and I augment libraries and prisons. So I have occasion to talk to prisoners, I have occasion to talk to correction officers, wardens. And then going back to where I was when I was sentencing, I was frustrated that all I could do was give somebody, like my colleague was talking about, with all these deficiencies, that all I could give that person was a term of years. And I would like to have had the opportunity and the authority to tell the executive branch what I want them to accomplish with this person that I'm giving to them. I'm going to give this person to you for 2 years. Now here's what I want you to do. Education is one of the things. Job training, soft skills in how to apply for a job, how to dress for a job. and all of these things. And then when they have accomplished this, then let them out. But I thank you. But I can't do that. And so I would say to you, if there is anything that you can do within the prison system to affect these kind of changes so that a judge could impose a sentence on them that is productive and saves people's lives, saves people's money, and overall will provide a reform-minded, not a sentencing, not a punitive system. I have also campaigned against the idea of punishment. Not that some people don't deserve it, but I'd like to see more of a focus on contain and then correct, and not make it so punitive, but build some humanity into it. So if any of you could if you're in positions of authority, where you could lobby for that, if you are employers, if you own companies, if you can hire people who are coming out. When people hit the streets, they have a couple of things that they have to think about, one of which is a job, one of which is a place to live. And if they do not find these, what we refer to as the pull of gravity, they're going to end up right back where they were. So I would urge you, I would encourage you to follow undoubtedly your instincts. You're here, and try to pursue these changes with whomever you have whoever will give you their ear, I'll put it that way. But switching around a little bit, I want to thank you for giving my colleague and I and me the credit for pulling the laboring oars in the federal system, and these 9 up there just sitting around doing 80 cases a year.
Yeah, thank you.
Certainly.
But, and back to the case on the video. I see that more as maybe I've seen it more often reviewing cases than my colleague has, but they had him anyway on a destruction of evidence charge. It's a felony. They didn't have to tack on these extra things except maybe to have some leverage in negotiation, and I do see that, and so I don't think it's an aberration. It's an overcharging, maybe not an overcriminalization there. I think the act was made necessary by what was going on in the Enron and all of that, where they were just destroying evidence, by the carload. But it certainly was unnecessary in this case. And I was a bit surprised by the dissent in that case written by Justice Kagan, that where she said that we are not in a position to be rewriting laws that have been passed by Congress. And I thought, when I read that, I thought, we're not. We do this all the time. We apply laws. And if they don't make sense, we try to make sense of them. And in this case, a shredding statute just does not apply to fish. And it shouldn't have been a difficult case to come up with. So I was surprised that it was so close. It was a 5-4 case. Did I cover the field for you?
Absolutely, but I want to push back just a little bit, because if somebody were to come in and take issue with what you're saying, especially with some of the points that you've made about criminal justice reform and giving these people second chances and things, they may say, Judge, you've been singing this song since at least 1995 is the first article by you that I read on these issues. You've probably been talking about it even longer. And they would say, but look, Judge, since 1995, we've continued to incarcerate more and more people for longer and longer periods of time. It's only till very recently that incarceration rates started declining in the country. And we're safer than we've ever been. We've got the lowest crime rates in this country we've had since 1968. So doesn't that suggest that we were doing the right thing by locking up more and more people for longer periods of time?
Maybe. Maybe not. Post hoc, ergo propter hoc. Are we going to buy into that one? I'm not. The problem is with that thinking is we don't know why. We haven't really studied the problem that much. We don't know what caused. Back in 94, 95, during the Clinton-Reno years there was a leveling and a slight decline going on when I wrote that article. And in there, where I talked about that decline, I said, one of the problems is we don't know why. Some people are saying it's because of increased incarceration rates. President Clinton says it's the tougher laws that we have. We're getting tough on criminals now. but we don't know. We don't know what that is, and what's scarier is if it ticks back up again, we will not know why it's ticking back up. So I think we have to look at these problems, crimes, criminals, like dread diseases, and start studying them. I mean, we can't just remove the cancer from the body and smash it on the floor. That won't do any good. You know, we have to study it. What caused it to begin with? As my colleague says, we have to know from the beginning, before the crime is committed, why and what we can do to prevent it. So I think that the answer to that is that we need to know more. And I would have no problem with doing whatever is necessary to protect society, but I strongly suspect that we do not have to incarcerate as many people as we do to protect ourselves.
Judge?
I think part of what this foundation can do, as well as so many other foundations that are interested in doing something about this, is there has to be some time spent educating the public. This cannot be done without public support. For those of us who live in the communities that we live in and run into people at grocery stores and they know what you do for a living, their viewpoint is very different. And a lot of it is their lack of understanding with regards to rehabilitation and what can be done and how to make things better. But to be successful in what I think the goal of all of us is with regards to having a criminal justice reformed in such a fashion that can be done, requires the public to understand the expenditures, the results, the betterment or lack of not making somebody better, and basically back to my theme, the necessity to do something before somebody even gets to the criminal justice system. But you need to educate the public because, you know, I watch the news and some of the reaction all of a sudden to something that happened almost a year ago and that was well thought out is kind of surprising to me, but it has traction. There are people that will approach you and say, you were on the Sentencing Commission, you allowed 6,000 people out at the same time, blah, blah, blah. And you have to take the time to explain it and how this works and the recidivism studies and everything else. And so it does require focus on that from the standpoint of having people understand what their resources are, how their resources can be spent better, and how the results can be better.
You know, I was thinking earlier, this will probably be our final question since we need to get to Q&A in a moment here, because I want to end on a happy note. You've been doing this a long time. There must be things that the criminal justice system does well. What do we do well in the U.S. criminal justice system? Anything?
I think we can be very proud of the way we conduct our criminal justice system in the courtroom. The fact that we have excellent defense for people who cannot afford a defender. The fact that we provide interpreters for anybody who doesn't understand how the system operates. The fact that people are treated with respect within the criminal justice system, at least within the court system. I may not be very popular, but I don't allow people to come in shackles into the courtroom. And that may be a safety concern on the part of the marshals, but they live with it with me. I also don't have them come in orange uniforms or whatever uniform there is. They get to wear their own clothes. I think from that standpoint, we can be very proud of our system. And we're dealing with so many people from other countries. When you explain to them their rights and the puzzled look that they have, like you're from Mars, as to, do I really have those rights? And you try to make them understand, yes, you do have these rights, even though you cross the border illegally. Everything that I tell you here applies to you as much as it does to somebody who was born and raised here. And from that standpoint, our system works very well. We may have some faults with regards to length of prison sentences and over-incarceration in some of the state systems, but as far as the actual conducting of the process, I think it works very well.
Judge Nygaard, what do you think?
I agree. I'm very proud of the judicial system. I think we do a great job. Viewing it from the point of view of a court of review, every one of those cases that comes up to us, I tell my law clerks, my new law clerks, I caution them, in there someplace there's another Gideon v. Wainwright. There's someplace of some guy who needs us to look this over very carefully, take it very seriously. And I know of no judge on my court or any that I've dealt with in the federal system who doesn't think that way. I'm a defender, strong defender of life tenure, which we have as federal judges, and I've been a critic in Pennsylvania of the election of judges because I saw there that some of my colleagues were a little bit too responsive to public notions where we, in the federal system, we only have to answer to that blind lady of justice and make sure that everything we do is fundamentally fair. I'm also one that, at least in our area, I hate to see the police get beaten up too badly because the ones that I've dealt with in our area up there have been good. And the ones that I've dealt with are trying very hard under some very trying circumstances. And mistakes are made, and when they are, we read about them. But the ones I've dealt with, I feel that they deserve a pat on the back from time to time. You mentioned the defense work. The defense work in the federal court is much superior to that which I saw in the state court. And our reviews on habeas corpus of ineffective assistance of counsel, there's some places where we need our standards upped a little bit to have better defense attorneys.
Well, we're going to turn to some audience Q&A right now, and I should ask the CKI team if we got a roving microphone or mic set up. Yeah? Fantastic, okay. So we've got one microphone set up right there, and if anybody's got questions for our judges, please, by all means, just, oh, and then there's another one right in the center. Let's go right here. Is that Professor Colbert, in fact?
Yes, it is.
There we
Thank
go.
you.
Oh, Professor, your question for our judges this morning.
Hi, my name is Doug Colbert. I'm a law professor at Maryland Law School. And when I hear you speak about the federal system, I think the remarks that you had towards the end really show how much difference lies between the federal system and the state system. So my students and I have been working for years on the pretrial justice system, where people in many places do not have representation when their freedom's first at stake, and where money usually decides freedom before trial or incarceration before trial. As I understand the federal system, in most places, money is not used to decide freedom, but you have more of a risk assessment, or you have more of a empirical data that helps. And there's always lawyers at that first appearance before the magistrate. So is there anything that you can or want to tell state judges or are able to tell state judges about the benefits of the way in which things take place in the federal courts?
Unfortunately, that's not an issue that the judges can solve. That's an issue that has to be resolved through the funds being made available for representation and good representation from the start. And we're lucky at the federal system that the defender services and the panel attorneys get funded, and that we do start from the very start. And I guess the judges, the advice would be stand up and speak up and say things need to be better within our own state system in order for us to protect people's rights and therefore the rights of all of us when we are inadequate with regards to representation and the resources available for people from the start as far as good representation and the tools needed to represent someone.
Yeah, unfortunately, in the federal system, we have the funding to provide that. In some of the counties, it's very difficult. Now, when I was a young attorney back in the early 70s, I could expect a call from a judge saying, Nygaard, you're defending so-and-so, get in here, and that sort of thing. And we even did a bit of that. When I was a judge, we would call somebody up and say, hey, I really need you to take on this defense work. And it may be somebody who is a high-paid, high-powered lawyer, but we would call them in and cajole them and try to get them to take a difficult case. So I'm not sure that we can sit here and say what state trial judges should do, but that was something that we did back then, and just to make sure that we had good lawyers, not just competent lawyers, but hardworking, knowledgeable lawyers who are taking on sometimes very minor cases.
Right here.
Good morning. My name is Judge Jim Gray. I'm a trial court judge in Orange County in California. And from my experience, I have seen that these mandatory minimum sentences simply do not work, and no one in advance should know what a sentence should be without knowing who the perpetrator is, etc. I also understand that there is a vast disparity of sentencing. So my proposal, and this is my question, why don't we have, and again, I know that federal district court judges are vastly overworked, and I think that's a tragedy. But if we were to have a sentencing panel of, say, 3 judges, so the 2 of you and 1 of your colleagues would sentence on all 3 of your cases, then we would probably get more in the middle, and that would be my proposal, instead of having mandatory minimum sentences. What are your thoughts, please?
Sounds like a pretty good proposal. I mean, if you can pull it off, I don't know what the laws are in California or how you work it out, but that might bring people together. I've not been familiar with situations such as my colleague was talking about, where one judge would max them out and one judge would give them the minimum. There are disparities, but not all disparities are bad. They shouldn't be vast. They maybe shouldn't be too wide. But as with you, I believe we should sentence the individual, not necessarily what he or she did. That's an integer of the equation, what that person did, because what you do gives you some indication of what you might do, but it's not the total. That's an interesting thought. That's something that maybe you could do in the state. But if you give it a try, let me know how it works.
Judge?
You do hear some of that in the federal system, that some places are doing that. My concern over that is that these 3 judges meet privately, and so neither the prosecutor nor the defense attorney is there during the conversation of what's going back and forth and what issues are being brought up. I think one of the great things about the Sentencing Reform Act with the guideline determination is we publicly have a discussion with both sides present about what's bringing me lower or higher here and what factors. That before the guidelines, I, of course, considered all those and never even had to tell anybody. And, you know, when you have an open system with transparency and both sides being able to respond, it's much better than a private meeting of 3 judges having discussions among themselves that neither side really got to respond to as to what was going up and down with regards to the sentencing. That gives me some concern, although it would make my job a lot easier to have 2 other people give me advice that I trust and believe in their judgment also, but it does raise the transparency issue as to how you handle that unless all 3 judges sit at the same time at the sentencing hearing.
Let's go back to this microphone on the left.
All right, I want to thank you all for your service. First of all, I'm Candy Kristoff with Reentry Solutions out of Alexandria, Louisiana. And my question is kind of twofold. One, what can be done? What state action can be done, or what can be done so that the persons who are in similar situations from those that, of the 6,000 that were released, can be released at a state level? That's one component of it. And the other one is it possible for us to have a diversion program prior to sentencing that would allow for consideration of education and those barriers that cause them to be involved in criminal mischief? And could there be something ideally like a one-time forgiveness, where if you go through this particular program, you meet the requirements for education, employment, treatment, whatever, etc., then you are forgiven at least a one time for criminal involvement in mischief?
Well, of course, it depends on the laws of your state, but there are programs out there that have a bit of forgiveness built into them for juveniles. We have one in Pennsylvania for first offenders on drunk driving. They're put on accelerated rehabilitative disposition, and they have to abide by certain guidelines for a year, and if they're successful, the record is expunged.
I'm talking for adults.
Pardon? Okay.
I'm talking for adults.
Well, I've advocated for that. I wrote an article years ago called The Role of Forgiveness in Criminal Sentencing, where I advocated that should be expanded to adults also. Okay. And that having achieved a certain threshold of rehabilitation, that they should be able to have their record expunged and start over. There are analogs in the civil side. In bankruptcy, we have a fresh start where all of your debts are wiped out, and you're given enough to start over again, and you have a fresh start. I think that perhaps that would be wise to consider in the state, but you would have to take that up with your state legislature.
Judge Hinojosa, you want to comment?
We actually have deferred adjudication in the federal system, but it doesn't seem to matter who the prosecutors are. It is rarely used, but it is there and can be used. In the state of Texas, we do have pretrial diversion for adults, and so that works. And deferred adjudication would probably work in some of our cases, but it has to be the prosecutor who comes up with it, not the court.
Well, we have time for one final question. Let's go to the mic on the right here.
Gentlemen, thank you guys for your time. You mentioned something earlier about identifying factors that seem to be common denominators as to what brings individuals before your court for sentencing. And I was wondering if there's any common denominators or factors that you've identified for the motivation behind overcriminalization. Obviously in Florida, they're very serious about their fish out there. But what about overcriminalization overall? Are there any common denominating factors that you notice? Any one of you can answer.
I'm not a believer in the fact that we have racial disparity in the criminal justice system based on racism. I do think it is related to socioeconomic factors. Whites with the same kind of socioeconomic factors as some of the Hispanics and African Americans in the federal prison system are there at a higher rate than whites who do not. And so I am a firm believer that until we fix the problem in society as a whole, we will continue, unfortunately, to have that kind of situation. And we need to be honest as to why we have it. We have disparity within different ethnic groups in our country based on income, education, and that's whether you're violating the law or not. And so therefore, we need to understand that that is an issue that needs to be taken care of before we get to the criminal justice system, or we will continue to have. And one of the things that you do have some thoughts about is some of the reforms that are being talked about. When you listen to them, you're going to say, you start thinking that's still going to continue the racial disparity because the people with those kind of those qualities are going to be people that are employed, have good education, income, those kind of things that it might benefit some of the people in some of these reform talks. And so we need to understand that if that happens, we're going to continue seeing the same kind of racial disparity as to who's in prison. And so we need to be honest with ourselves as to when to fix it and how to fix it. Don't ever underestimate the ability that we have as individuals when we come across people within our own communities to encourage them to help them and to do all sorts of things. It's government and people who make a difference with regards to how people do and how their life gets better.
Judge Nygaard.
I would take issue with that. I believe that, especially in some parts of the country, there's great racial disparity in the justice system. And I admit to a bias. I'm a life member of the NAACP, so maybe I'm looking more deeply into this, but I think there is that racial disparity. But looking at what my colleague here is saying, there may be ways that we should look at how we address those things. I was lecturing in Georgia to the Mid-State Educational Association, I think it was called here, some years ago, on this problem. The whole group had advanced degrees of one kind or another. And in the questioning that followed, a person who was a child psychiatrist or almost neonatal psychiatrist challenged me on some of my points, and I said, okay, tell me when we should start working with people who live in deprived circumstances, educationally, culturally, whatever. He said, he thought for a minute, and he says, about the age of 1. And so I said to these people out there, I said, well, maybe what we should be doing then is putting our PhDs in preschools rather than in universities. So we could start working with this problem of enculturation, of education, and get people ready for life. And I didn't get much agreement from them, but I still keep proposing. But yeah, we do have to do, we have to, you know, here's another thought too. Where do we have people all together, all at once, where we can begin to work on these issues with them? In school. Perhaps what we should be doing is maybe take Nygaard seriously about that preschool and start teaching kids life skills, start teaching them simple rules of morality, simple rules of cultural expectations, simple rules of honoring each other's integrity, physical, mental, and otherwise. I used to talk to my boys when they were young about what I called my 3-word rules. Leave me alone. Don't touch me. That's not yours. That's not mine. And it was effective. I remember one time my youngest son came home and he told me, he said, Dad, he says, I found a great hunting knife. He says, it was really something. I said, well, let me see it. He said, well, I didn't, it was on the sidewalk. It wasn't mine. I didn't take it. You can teach these things. We can get to people. And maybe that's where we can do it. We can start adding to the curriculum people, kids in school, to get them prepared for what they are going to have to expect in life.
Well, before we leave for the morning, I wanted to note, I should have said this when we kicked off. You may have noticed in your program that Judge Paul Cassell was supposed to join us, but obviously he's not here. He did want to send his regrets, but nevertheless, I think we had a fantastic morning conversation. I was deeply honored to have the chance to talk with the two of you this morning, and I hope that everybody will join me in giving a round of applause to our two judges.
Thank you.
I actually think we should applaud you for your interest in this subject. Absolutely. And for what you all do and the interest that you're paying in the work that you're doing.
Kind.
Well, once again, thank you so much to our panelists. That was great. Ladies and gentlemen, the breakout sessions are going to begin at 10 o'clock. There are signs outside the rooms indicating the rooms. And you can also look for the staff that are wearing the Ask Me buttons if you want to know which room you're trying to get to. As a reminder, please do visit the galleries on this floor with our featured nonprofits. They have tables set up. These are groups whose great work we particularly want to highlight. So with that, let's head out to the breakouts. We'll be back in here for lunch, and I hope you enjoy the rest of the programming.